Okay, doke. There you go, Ryan.
Thanks so much, Luann. Good evening, everyone. Good evening, everyone. My name is Ryan Murray. I'm the Executive Director of the Washington Association of Child Advocate Programs, and I'm here tonight to talk about a little bit about the court timelines and process when it comes to dependent children, kind of how we set things up, what the court side of things looks like. I know it may seem a little confusing, especially for those of you who haven't been through this system before or have familiarity with this system. And so I'm just going to try to explain it a little bit, kind of the different stages and kind of what the expectations are of the court during each one of those phases of the court. A couple of things. Yes, I have a cold. 2, I also got a migraine while I was working on this earlier today. So if I'm a little loopy, that's all. And sometimes I'll have to adjust my glasses just so I can read what's going on. But other than that, we should be just fine. And I do not mind questions during or throughout. So if you have a question about a particular slide, I will ask that you either put it in chat and Luann can flag me down and do that. That way I don't have to monitor the chat. Or if you don't mind, like Luann said, having your face come on and asking the question verbally, that's okay with me, or whichever you're more comfortable with. So with that, I think we'll go ahead and get started, unless there are any questions or table setting that we need to do before we dive into the rest of the presentation. Anyone? Okay. Well, to give you an overview of kind of what the process looks like, this is a slide that kind of shows the overall court process, kind of the timelines and what we call different phases of the court process. And this is like trying to take an orange, a 3-dimensional orange, and then smashing it down into like a 2-dimensional object. So this is just like this is not how every court proceeding goes. It's basically just to kind of give you the outline of the way things should happen or can happen, but it's every hearing, every process is just a little bit different. But this is in general the general flow of the court process. And so I'm going to go over each one of these individuals, but let's go over this very briefly. So the dependency court processes are divided into 3 stages. So there's pre-court involvement. And so that's where DCYF or the department potentially may be working with families. That's where CPS referrals come in to the system. They go through the DCYF's process of kind of assigning whether maybe they either go out to investigate directly the allegations that are being made, and from that investigation or those communications that they've had with the family, either maybe go a voluntary services agreement, family alternative response, or they may just jump straight into the whole court process. I'm not going to spend too much time on that because that's all we call all that stuff pre-court involvement. The next phase is called shelter care. And this is where the court is really, and all the people are gathering additional information. It's an emergency type situation. It's just called shelter care. And that lasts until an order of dependency is entered or the parties agree that this is a dependent child, and then that begins the dependency phase. Shelter care is really only meant to last maybe 90 days. Statutorily, it's 75 days, but 90 days at max, although that can be extended. Dependency is where the bulk of the time, where the bulk of the stuff that happens during a dependency is happening, right? So shelter care is a very short phase. Dependency is the long case phase. That's where we have 6-month review hearings, et cetera, et cetera. And we're going to go into each one of these stages a little bit clearly, but I just kind of wanted to lay that out to begin with. Yeah, I think I'll go ahead and get started. So the whole thing that kicks this off, the whole thing that starts a court process when it comes to child welfare stuff is a dependency petition. And what this is a document that a social worker, usually it's the CPS worker, but a social worker writes up and provides to the court of allegations of why the parents can't maintain safety for the child. That's all it is. It's just a list of allegations. Here's what we think is, and it's basically a letter or a declaration to the court just saying, Your Honor, here's why we think it's not, why this kid is in an unsafe situation. One of the things that this document must include is also why there is a threat of imminent physical harm to the child. And the reason why the social worker thinks any safety threat is imminent. That language has changed, and I'm sure many of you know, with a couple of recent legislative changes. And so there's an argument to be made that the standard is a little bit higher, meaning that the court can't remove a child from home unless there is an imminent physical safety threat, imminent physical harm. Now, it doesn't mean, I'll just put this out there, and this is where part of the legal arguments kind of come out there as well. It doesn't mean that we can't start a dependency process. It just, that standard is for removal. Okay, that imminent physical, that threat of imminent physical harm is a threat for, it's the condition that the court has to apply for removal of the child from the home. It doesn't mean that we can't establish dependency. You with me so far? Okay. And there is a whole bunch of legal arguments going on back and forth about whether or not, essentially, do we have to have a removal in order to start a dependency? Could we start a dependency process without removing the child? And the drafters and the people who wrote 1227, they just wanted to make sure that we were removing children from their homes as a last resort, meaning we tried everything else, but it was a last resort that we needed to remove, and that really the court should weigh in on that, and that should not just be a decision based upon allegations. However, many people have interpreted that, many of the attorneys have interpreted that as meaning that you can't have a dependency unless there is that imminent, that threat of imminent physical harm. And so some jurisdictions have negotiated that, or what that looks like, and so that you could potentially have a dependency without removal. But most of the state's attorneys have come to the conclusion that you can't start a dependency unless there's a reason to remove. And so that's where a lot of these arguments are coming from. And I've heard both sides, and it's a legal thing, right? I'm not an attorney. So it's the attorneys and the courts are the ones that are kind of wrestling with that. This dependency petition must be served to both parents, and that means that they receive that petition and the allegations in it. They have to receive a copy of that prior to being able to continue. So they have to be served the paperwork. This will also include information of when and how parents should show up for the initial court hearing. So basically where to go, what time, and that to show up for that initial hearing. A petition often includes what's known as a pickup order. And what that pickup order gives the state permission to do is put the child in protective custody, which usually means foster care or a relative placement somewhere other than that kid's initial home. Questions about dependency petitions? Good. So a little bit more on the pickup order, or similarly, a hospital hold. So sometimes we'll have newborns that are born and the hospitals will say, we don't think it's safe for this kid to go home, so we're going to hold them here, right? We're not going to let them to go into the custody of their parents. So pickup orders, hospital hold, kind of the same thing. It's basically saying to the court, it's not safe for the kid to go home or be home. And these pickup orders or even hospital holds gives the state the legal authority to place the child in the care of someone other than the parents. So that could be a foster parent, that could be a relative, that could be the hospital. And that hospital hold remains in effect until the shelter care hearing. Right? A couple of other things to know about pickup orders and hospital holds. There's no argument in court about these. The judge simply reads what the social worker is saying about this family situation, or the hospital is saying about the family situation, and decides whether to put the child somewhere else or allow them to remain with the parent.
Ryan, there are a couple of questions.
Awesome.
Are dependency petitions or any of this initial paperwork available to foster parents once a child has been placed?
No.
What is the process when a child comes to the attention of the system via police, maybe during an event where they are called?
So similarly, that's kind of like a pickup order too. And so sometimes the police can also decide whether or not it's not safe for the kid to go home. So we call those, it's the same thing, whether we send the police out to go pick up the kid, or the police say, we're not going to let this kid go home. Right? It's that same idea it's the same idea of pickup orders. So it's what those temporary orders allow is the court gives the state authority to say, kid can't go home, and here's where they need to be instead. One of the other things I want to make sure that you're aware of too with these pickup orders or hospital holds, there's no argument in court, right? So at this stage, parents don't get the opportunity to say that's not what happened or present their side. It is basically the court relying on the word of the social worker about whether or not to sign these hospital holds, pickup orders, protective custody pieces until that initial shelter care hearing. Now, when that dependency petition is filed, there has to be a hearing within 72 hours, and we call that the shelter care hearing. So, and we'll talk about that on the next slide, but these pickup orders or these hospital holds are generally only good until they're temporarily in effect. So temporarily in effect meaning until we have that shelter care hearing within 72 hours of filing all this paperwork. Now I want you to imagine that it is 4:30 on a Friday afternoon before the weekend, and you're a judge reading these dependency petitions, pickup orders, hospital holds, and having to make a determination of whether or not the child can go home, or should we keep them in foster care over the weekend? What do you think most judges say at 4:30 on a Friday afternoon before the weekend? I'm going to tell you so that you don't have to guess. But basically, because I've sat with judges when they get these and they're like, oh my gosh, what a poorly worded, I wish I had more information is what they say, right? Like, I have so many questions about this. I don't know that there's enough here to warrant putting the kid in foster care or in protective custody over the weekend, but I'm going to err on the side of caution. And I'm going to go ahead and sign this, and then we'll sort it out next week when we have court. So behind the scenes, what's happening in courts, once that petition is filed, there's an email that gets sent out to that goes out to all the court participants. So the parents' attorneys, the AGs, like basically everybody's like, hey, there's a email that goes out and say, heads up, we got a new one. Be ready, guys. right? So the parents' attorneys will figure out who's going to be covering that hearing. CASAs or GALs may send people to that hearing, but basically it's letting everybody know we've got one coming in. We've got a new filing that's coming in. Be ready. And what that looks like from county to county varies wildly. Some of them have a system down where as soon as that petition is filed, everybody gets an email with the petition so that they can start figuring out and doing conflict checks. In others, they may not know until the day of the hearing. So I just want to take a moment to explain who are parties to the case, because I'm going to use that word a lot. So parties are the official participants in the case. They're the ones who will be able to file motions, call witnesses, file responses to any of the court proceedings. Parties include parents and their attorneys, the social worker and the assistant attorney general, who represents the state. So those two are kind of a team. The child's guardian ad litem or the child's attorney, but not the child themselves. And sometimes the child's tribe, if the child is Native American. Everyone else is not considered a party and only have limited ways that they can participate in the court proceedings. So caregivers, foster parents, relatives, anybody who's not a party cannot participate in the court process unless they're asked to do so. And when I mean asked, that means asked by one of the parties to participate or write a declaration or be called as a witness. Luann?
What is a conflict check?
Oh, conflict check is what attorneys do to make sure that they haven't represented the client or have some other history with the client from a previous court hearing or previous legal matter. They want to make sure all the attorneys who are working with the client have a clean slate. Or that we have a lot of folks too that switch sides. So some go from the attorney general's office to parents' attorneys to parent representation or child representation or vice versa. And so they just want to make sure that there's no conflict in their representation of their client. Judges do it too. Because before judges came to the bench, sometimes they were AGs, or sometimes they were parents' attorneys, or sometimes they were just attorneys in general, and may have represented one or more of the clients. And they have to look and see, oh, have I ever represented that person? If so, they have to say, I have to conflict out. I can't be the judicial officer on this hearing because I have a pre-existing relationship with this client. So somebody had asked earlier if they could get documents like the petition. Could they see, could somebody see the petition? No. And the reason is because you're not a party to the case. And these documents within these types of cases are considered sealed, and non-parties can't have access to them. Now, there are some exceptions to that. But I'm not going to. I suppose technically a parent could share their dependency petition with a caregiver because it's their document, it's their court hearing, but I wouldn't mess with that, and their attorneys will probably freak out if that ever happens. So don't ask. So I also wanted to just take a moment here to talk a little bit about the caregiver's report to the court. So one of the most important ways you can let the court know about what's going on from the child's perspective is through the caregiver's report to the court. There is an official form provided by DCYF that you can download from the DCYF website that allows you to report to the court what's happening with the child from your perspective. You can, once you complete that document, you can give it to the child's social worker, you can give it to the child's guardian ad litem or attorney, or you can file them directly with the court. Please have those completed 2 weeks prior to any hearing. And just another thing I want to be clear about, the caregiver's report, the court is really interested on what's going on with the child, right? And wants to hear from you as the caregiver of the child from the child giver's perspective. And so you'll see a lot of the questions in there are just asking about how the kid's doing with certain aspects of the case, you know, and so that's really what the court needs you to focus on, not what you heard about the parents or not what, you know, like those sorts of things. They just want to know how the kid's doing from your perspective.
Ryan, a question.
Uh-huh.
How and when should caregivers be notified of a hearing? For example, we found out the day before a recent hearing, and so had no time to complete a caregiver report.
Thank you for that. You should be in contact with the social worker. They're the ones that can tell you that information. And technically, they're the only person who can. We have some jurisdictions where the guardian ad litem would be allowed to, but some jurisdictions where that practice is really frowned upon because they consider that, the court considers that a breach of confidentiality. So the only person really that you should be relying on is the social worker, and asking the social worker if there are any upcoming hearings. The challenge, and I get this, and I don't know what the answer to this is, guys, but sometimes there are going to be motions that are filed, and sometimes those motions are going to be immediate motions on shortened time, where there may not be enough time to gather that caregiver's report. But most of the hearings that I'm going to be talking about here follow within a calendar and a timeline. So you should have some idea of when the regularly scheduled hearings are happening, maybe not motions. And I wish I had a better answer for that, because you don't know what you don't know, but that's the way it is, guys. The other thing I will add here is that courts are open for any of these hearings, meaning you can go and watch. You can't testify, you can't add anything, but you can go and watch the hearings if you want to. But don't be expected to participate in the hearing unless you're called to do so.
Ryan, is there another, I have the Pierce County link for the court, but do you have a website or know where I could access it to post it in chat for people to know? Oh, alrighty. Well, that's the form, but the court, to file it with the court, if they wanted to take it to the courthouse?
They can just take it to the courthouse and talk to a clerk there and just say, I want to file this.
Okay.
But really, don't worry. Or many of you are on email threads with the social worker, maybe even the GAL. Just post it to that thread and say, hey, here's my caregiver report. Could you make sure this gets filed? Because if you walk into the court or try to email it to the court, they may not know what to do with it. So you're better off going through the social worker or the guardian ad litem. And they won't touch it, they won't read it, they'll just submit it as a piece of paper. So if you're not getting along with the social worker, give it to the GAL. If you're not getting along with the GAL, give it to the social worker. One of those two will file it. All right, let's get back to the timeline. So the emergency shelter care hearing must occur within 72 hours, 3 business days of the filing of the dependency petition. Parents will generally meet with their assigned public defender attorneys at court immediately before this hearing, right? With only 3 days, there's not enough time. And so usually what happens is at the day of the hearing that's listed in that petition, they'll meet with an attorney, a parent's attorney. The parents will meet with an attorney. So each parent gets their own attorney. They'll meet with them. And that may not be the parent's attorney moving forward. A lot of practices or a lot of places just say, I'm the attorney of the day. I'm here to represent you for this specific hearing. What do you want me to let the court know? And at this hearing, the court's really only looking at a couple of things. Whether the allegations in the petition are more true than false. It is a very low bar. It just has to be more true than false. When it comes to Alexa off, sorry. They'll also be looking at placement, where the child should be. And parents suggestions or offerings of where they want the child to be placed are given preference. So if a parent says, I don't want my kid to go into foster care, I want I want my mom to take care of them, or dad's mom, whoever, the court has to consider that and give that weight. And if the child is placed out of home, what visitation will look like between the parent and the child. These emergency hearings can be either agreed, where everybody sits down together and says, yep, their kids, we're going to voluntarily do shelter care, or we agree to this court process, or contested. And if they're contested, that's where a full-blown hearing can happen. Luann.
Can the bio parent sign a VPA at the shelter care hearing, or has the time already passed for them to do that by then?
If the state's already filed a petition, they're probably going to continue with, so at that point, it wouldn't necessarily be a voluntary. They can sign a VPA, but more often than not, what's going to happen is the parents' attorneys are going to say, we'll agree to placement with the person who is going to be that VPA person, but we still want the court proceeding to happen, because at that point, the state's already invested a lot of energy and effort in filing the petition. And so, and quite frankly, especially for the relatives out there who may be taking care of their kids, once the court gets involved, there's another person involved to make sure that the department is doing what they said that they were going to do. And that's the judge. And so while you may think, oh, I don't want the court involved, or I don't want all these people as a relative placement, you don't want these, there are going to be some things that will happen, and services and resources that you're going to have access to that you wouldn't under a voluntary placement agreement. There's financial stuff that's available. And once we get a little bit further along in the process, the court can order the parents to do things like go to treatment, get yourself clean, where with a VPA, you're not going to have that. Luann?
If the child is in placement for about 5 months and doing great, can the parents say they want the child moved?
They can say that, and they'd have to file a motion to do so. So let me talk a little bit more about this process so that you get a, so at this shelter, and then we'll see if we can, hopefully some of these questions will be answered. So at this shelter care hearing, they're basically just looking at 3 things, whether it's mostly true or false, where the kid's going to be placed, and what visitation is going to look like. Supervised, how long, frequency, all that good stuff. The result of that hearing is what's known as a shelter care order. And this is a legal document that comes from the hearing. And it's the same whether it's contested or agreed, right? There's going to be a shelter care order. And what that shelter care order does is directs the parties, parents and the social worker, what they can and cannot do. That shelter care order will also assign the child a guardian ad litem or an attorney. And there's also an initial contemplation of whether or not the child is Native American. Is there any reason to know that this child may be Native American? If so, that kicks ICWA into effect, the Indian Child Welfare Act. And what that is a series of statutes and laws to make sure that kids who are enrolled in Native American tribes or eligible for enrollment get the full benefit. Get the full benefit of those ICWA statutes. Oops. And then finally, these shelter care orders remain into effect until a fact-finding hearing or an agreed order of dependency. So during the shelter care phase, the shelter care order is kind of the law of the case. It's what the judge said. So, and if somebody needs to, can I talk about that? Yeah. These orders stay in effect until the fact-finding hearing or an agreed order of dependency. And the only way that they can be changed or modified is if somebody motions the court and asks the court to change the existing order, or all the parties agree to the change and the court's okay with the modification. It is important to note the court cannot order parents to do anything, treatment, services, etc., while the case remains in shelter care status. So while the case stays in shelter care, the court can't say, parent, you need to go to treatment. It doesn't mean that the parent can't voluntarily enter treatment or go to those things or ask for those things, but the court cannot order it. One of the things that has been increasingly happening is that, so there's a reason why there's an asterisk here. If the court says, all right, parent, kid can go home with you today, but here's what needs to happen. Here's what I need. Here's what you're going to do. They can tell the parent to do something as a condition of placement. So the court can say, I'm going to let the kid go back home, but you're going to start treatment tomorrow like you said you were going to. And if you don't, we're going to come back here and the child's going to be removed from your care.
Are court orders available to caregivers to read to know what exact parameters of the placement are?
No. All of these documents are confidential. You guys are going to have to get your information from the social worker. GAL can't tell you either. All right, so after that initial shelter care hearing, the 72-hour shelter care hearing, and the order that comes from that, every 30 days, there's going to be a review. So basically what we call them 30-day shelter care hearings. Every 30 days after the initial shelter care hearing, the court brings everyone back together and says, okay, now that we know a little bit more, or hopefully we know a little bit more about what's going on with the case, what needs to change? And again, just like at shelter care, the two big things are going to be placement and visitation. And what's going to be asked is, do we know more about the child's safety situation, or how can the parents keep the kids safe? And are there better or more familiar placement options for the child? And I want to talk a little bit more about what we mean by family or familiar. Generally, that means have we located a family member who could maybe take care of this child? So maybe the child's aunt or uncle or grandma or grandpa, rather than foster care. Research has shown that kids do better when they're placed with family. It could also mean where we find like a fictive relative, somebody who's familiar to the child, right? Like a neighbor or family friend or something like that. But again, it's better to do that sooner in the case rather than later. Kids do better when they're placed with family, and it kind of helps us reduce that harm of removal, right? Just imagine if that were happening to you, wouldn't you rather go to somebody you knew rather than to go live with strangers? It's the same thing for kids. And federal and state statutes require that the case only remain in that shelter care for a maximum of 75 days, right? So from the time that petition is filed to when a determination is made about whether or not that child is dependent, that should only take 75 days. That happens about 2/3 to 3/4 of the time. So we may have cases where kids and families are staying in shelter care status longer than that 75 days. But that is the goal. All right. So the first big hearing that we have is known as the fact-finding hearing. Some jurisdictions refer to these as dependency trials. So it's been 60, 75 days. And what the court is going to be doing at this hearing is determining whether or not there's enough evidence to support that the child or children are unsafe in the parent's care for the foreseeable future, and what behavior change the court needs to see in the parents in order for the parent to allow the parent to assume full-time parenting responsibility without further state or court intervention. If all parties agree to what needs to happen, meaning they all agree, like, okay, mom's going to enter drug and alcohol treatment, mom's going to get a psych evaluation, like all these things are agreed to, it can be waived, and all the parties can get together and present an agreed order of dependency. The judge will look over that. Generally, if there's an agreed order, the court's going to be like, this sounds great. Maybe they'll tweak one or two things, but they'll just say, this sounds great. Where child is now dependent. If parties can't agree, then it goes to a full-blown hearing. Witnesses are called, evidence is presented, the whole trial, just like they do on Law and Order, right? Like they do a full-blown trial to determine whether or not the parents can safely parent their children. After that hearing, we're at the end of it. So everybody's, states made their case, the parents have made their case, the guardians ad litem have weighed in. At the conclusion of a fact-finding hearing, the court has up to 2 weeks to contemplate whether was enough information provided to deem the children dependent on the state for their safety and care. And what the parents will need to do in order for court and social worker oversight to end. The court will announce this at a disposition hearing. Most of the time, courts will do this right at the conclusion of the fact-finding hearing. But on particularly contentious cases, it'll take the full 2 weeks to kind of figure out what the plan's going to be. The end result of this process, whether agreed or contested, is a legal document known as the Order of Dependency. This is the document that the court and all parties will refer back to for the duration of court involvement. It spells out what the parent needs to do and show the court that they're able to be safe and fit parents. We have now entered dependency, the dependency phase of the case. And what that means is the child or the children are dependent on the state for their care and safety. After the child is found dependent, the parents also have a couple of options of how they want to participate. So we have regular dependency court or specialty courts. There's two flavors that we have here in Washington. We have family treatment court, and that court specializes in helping parents overcome substance abuse issues. We also have, we call these baby courts or birth to 5 courts or birth to 3 courts. And those courts specialize in helping families or parents with young children. Generally speaking, specialty courts have more frequent hearings, especially at the beginning, like FTC, like family treatment court, they may meet every week at the beginning, then they'll go to every other week, then maybe once a month, right? So they just have more frequent check-ins. Treatment courts also have professionals available to the court to kind of help guide service provision, make sure the families and everybody's getting what they need. They generally, family treatment courts and specialty courts have a team those are the only types of cases that they do. It's generally less adversarial than a team-based because you've got the same professionals working on the same cases, working their procedures and things like that, rather than a regular dependency court. Luann.
How do you know which one you're in?
Parents have to opt in to either one of these courts. So the court can't order a parent, hey, go into family treatment court to get, to solve your substance abuse issue. Parents have to say, I want to enter this court. Otherwise, they stay in regular dependency court. I will say that these specialty courts are pretty intensive, but they do have pretty good success rates. They're also a lot of work for the attorneys. It means a lot more hearings. And so sometimes they're not always sold, especially with parents' attorneys, not always sold to their clients in the most effective ways. It's a lot of work.
Kirsten is saying that their social worker told her that mom had switched to treatment court.
That's exactly what this is, Kristen. I will say each jurisdiction has their own names for these. Like I've heard lift court, I've heard treatment court, FTC, 0 to 3, baby court. Like there's all kinds of names for these. Okay. Once a child is found dependent, either through agreed orders or the court has said this child is dependent, the court is going to hold review hearings every 6 months to check in on the progress of the parents and to see if everybody's doing what they're supposed to be doing. This includes the department. The first one of these is known as the first dependency review hearing, and it needs to occur within 6 months of either when the child has been placed out of home or found dependent, whichever is first. Another type of these review hearings is, so the other thing that needs to happen during these review hearings is permanency planning, and this needs to be done every year. So a lot of jurisdictions will say, we'll call one type of hearing, one of these 6-month review hearings, just your standard review hearing, permanency planning hearing, review hearing, permanency planning hearing, review hearing, permanency planning hearing, on and on until the case is over. At these permanency planning hearings, the court will inquire about progress the parents are making and make determinations on what the primary option for permanency should be and the secondary. So they're going to have plan A for permanence and resolution, plan B. Generally speaking, especially at the beginning of the case, it's going to be reunification with mom or dad or both. That's going to be plan A. Plan B might be guardianship or termination, but termination is usually down the road. And permanency options is a whole other hour worth of training, right, Luann? Yeah, so we're not going to get into that. All right. Termination of parental rights. By state and federal statute, between 12 and 18 months after dependency has been established, the court will start asking the parties if the parents are making progress in overcoming the court-identified parental deficiencies. If the court thinks or everybody agrees that the parents are making progress towards those goals, it can enter a finding that there is good cause not to order the department to file a petition of termination of parental rights. This question about whether or not we should terminate will be continued to be, this is where you can see the migraine really starting to kick in, guys. They ask this question at every hearing after that 6 months, right? So between 12 and 18 months, they have to make the first one. And then at every hearing after that, at every review hearing after that, the court will ask, should we terminate parental rights? If the court finds that the parents aren't making sufficient progress or taking too long, it will order the state to initiate termination of parental rights. And the other, sorry, I was just looking to see. I just want to say this too. The court does not entertain termination of parental rights lightly, right? Terminating parental rights is one of the most severe actions that a court can take. It has been called so in criminal cases, the most extreme thing that you can do to a person, right? If they're guilty, if they're found guilty, the most extreme thing that the court can order is the death penalty. That's in criminal. In civil, which is where dependency happens, courts have said that termination of parental rights is the civil death penalty. When you terminate a child's right to their family, that is permanent and forever. And so before the court decides to do that, they want to make sure they've got all the ducks in a row. Because just like civil or just like criminal death penalty cases, the parental termination of parental rights is going to be appealed. And that appeal process takes months, if not years, to resolve. The state knows this, parents' attorneys know this, so they really, really, really try to avoid terminating parental rights when possible, especially if it's going to be contested. Here's the other thing to know about termination of parental rights too. The state can file all the paperwork, get all their, the court hearing, get all that stuff ready. And at the very last minute, if the parent says, you know what, I changed my mind, I want to keep my kids, I want to go into services the day before trial starts, the court basically has to say, all right, termination's off. So that's another reason why the state is sometimes reluctant to file termination of parental rights.
While Ryan's fixing whatever broke there, I'm going to say that we do.
Apologize, I had to switch my head.
Okay,
Go ahead, sorry.
We have a training on that is recorded on the CARE site, and I'll post the address here. Chris, you were asking if Ryan could talk about the difference between guardianship termination and dependency. And you'll find all that information in this training. I know Ryan could go over it all, but it's a whole separate training in and of itself.
And Ryan probably couldn't go over it all without doing a little bit more research. It's complicated. And it keeps changing all the time.
Yes.
So couple more slides just to kind of finish things up. When can the child go home? When the court determines that it is safe to do so, and where any identified long-term risks have been sufficiently addressed and taken care of. There is a much stronger push these days to put the kid back home when it's safe to do so, rather than waiting until the parent does every little thing in that dependency order. For example, mom or dad, maybe like a year into their treatment, visits have been going well, they've been extended, they're being unsupervised, maybe they're even starting to do overnights or weekends. At some point, the court can say, you know what, you still got some work to do, mom or dad, but it's safe enough for the kid to go back home. We're going to keep the case open to make sure that you finish out what you need to do, but it's safe enough for that kid to go back. Safety is the first thing the court's going to think about or contemplate when it's making that determination. Risk is the second, right? So immediate safety, is the environment safe enough? And have we taken the risk down from very high risk down to moderate or even low? That way we're not, because if we just relied on safety, we could run into a circumstance where we put the kid back, but it's, parents, it may be safe. I mean, just to use a timely example, if you've got a parent that's using fentanyl, right? And that's a documented issue, or even heroin or anything like that. Just because they've cleaned out the house and made sure all the pills are out of the way and everything like that creates a safe environment for that kid. But if they're still actively using, we haven't solved the risk problem yet. Now, parents' attorneys may argue, hey, it's safe for my child to go home, but the state and hopefully the GALs and everybody else are going to say, yeah, but we haven't solved the risk problem yet. And we don't want to put the kid into a risky situation. It may be safe, but it's still risky. So safety is immediate concerns, risk is long-term. Lastly, I want to talk about trial returns home. This is kind of being phased out. And it's because the courts are adopting a new way of thinking about child welfare. The old way used to be like, okay, you've got your dependency order, mom, dad, go do all of these things. And when you've done them all, right, when you've checked every single box, then we'll contemplate giving your kid back. We'll keep the case open for 6 months. If nothing happens, we'll dismiss. What ended up happening is we had kids that would stay in out-of-home care for really long times when they probably didn't need to be out of care that long, right? It was safe and the risk had been down low enough, even though they may have still had some things that they need to finish up, the parents. We just were keeping kids in out-of-home care for way too long.
Do visits typically get longer or more frequent first before the child goes home, or is it
They
into?
they should. They should. And what you'd want to see is, I have a whole training on visitation too. Luann, maybe that's when I should do. We could do visits instead of the safety versus risk. But ideally, like as the case, we've really been pushing more and more. We should be looking at the visitation plan every 30 days, right? There is no reason why a case, if mom or dad has been making progress, right? They're doing the work and we're still stuck on 2 hours, 2 times a week supervised, we're doing something wrong. Because, and this is my philosophy on visits, my 14-year-old could do 2 hours, 2 times a week supervised. That's not parenting. That's not proving his ability to parent. That's proving his ability to maintain an appointment. And if we want to know whether or not a parent's able to parent, we got to keep cranking up the pressure. We really do. And the defense attorneys will tell you that too. We should not be leaving well enough alone when it comes to parent visits. Anyone can do 2 hours, 2 times a week supervised. Anyone. Whether you're high, actively using, anyone can do that. And we are failing our parents and our kids by not cranking that up, to the max, keeping the pressure on these parents to parent. We should be I firmly believe we should be making parents parent their children as much as possible, as long as it's safe to do so. Because a lot of parents will tell you, I was just at a training yesterday, the parents were just like, great, you take my kids away from me at that initial shelter care. Guess what I'm going to do? I'm going to go out and use more than ever, because the only thing that was kind of keeping me grounded and kind of keeping me from being a full-blown or like just really going all out is that I had kids to take care of. Now you're going to take care of them for me? Perfect. And I've got 2 or 3 months to kind of play around before I have to really get serious and before the court's even going to think about dependency. I'm going to take full advantage of that. So visits are a good thing, and they should be, as we go throughout the case, they should be becoming more frequent. They should be becoming less supervised. Basically, this is where we're seeing if a parent can parent. And if they're going to fail, let them fail while you got all these eyes and people and support systems around them. So that's the new philosophy when it comes to visits. So when does this whole thing end? Court involvement ends when all the items in the dependency order have been accomplished and the parent is able to resume parenting on their own. This is known as dismissal. And dismissal hearings can occur as part of the regular 6-month review cycles, or can be special set or noted for a motion hearing so that everyone has a chance to recognize the accomplishments of the parents. But that's how it ends. Court involvement doesn't end when the child returns home. It ends when the parents have rectified their parental deficiencies. That's the end. And again, I apologize for the typos. I did not get a chance to go back and review after I hit send and went and took 2 aspirin and took a nap.